presenter today is Jordan Cullimore. He's an attorney with the Utah Office of the Property Rights Ombudsman. We really appreciate the Ombudsman's office and their willingness to come in and share these important subjects with us in regards to planning. They provide an essential service that helps us balance the needs of our local governments with private property rights. And Jordan's going to talk to us today about Planning Commission. Planning Commission 101. What do they do? How do they stay out of trouble? And that's really what we're looking at today. Jordan.
All right, thanks, Jason. Again, as always, thanks for having our office here. We appreciate the relationship we have and the opportunity we have to come and give these presentations. So in talking with Jason, he mentioned to me that at this presentation there will probably be a number of maybe possibly new commissioners, new city council members, new staff members. So I thought at the beginning we'd just kind of give a very brief overview of what our office does, how we can assist you, how we can be a resource if you're interested. So again, our office, we're under the Department of Commerce. We're a state-funded office with the mandate to act as a neutral third party in helping to resolve disputes in eminent domain and land use, and also, frankly, just to be a resource to local governments and property owners to understand what the laws are in land use and eminent domain, what individual property rights or property owners' rights are, what the rights of the community are in any given situation. So we're happy to help out in any way we can and be an informational resource. Please contact us if you have questions. We're here to help all sides and help everyone know what the law is and what best practices are and how to respect property rights, but also build good communities. One resource that we have available that's really helpful in land use context are the advisory opinions. And if you check out our website, I should have included the link to that, or the website here. It's propertyrights.utah.gov. There's a lot of good information just on that website that you can go check out. You can also request an advisory opinion. So, you know, if you've come to an impasse with a property owner or developer on a specific legal question, we get requests from both government entities and from the property owners, just looking for an independent look on how a court would view a specific land use question, a legal question, and how you know, certain ordinance should be interpreted or a law applied or anything like that. So that's one resource that we have available. But even prior to that, please give us a call anytime if there's anything you'd like to discuss, or if we could get involved to be helpful in mediating or resolving disputes, and even providing trainings. We're more than happy and appreciate the opportunity to come to your local meetings, the city council meetings, the planning commission meetings, and have one-on-one discussions. Because, right, planning is inherently a local endeavor. It's beneficial to have those meetings on a one-to-one basis and discuss the questions and problems that you're facing, right, as a community. With that, as I go through this presentation, we always welcome and appreciate participation. And so, you know, like Jason said, post away your questions, and as we're going, you know, we can stop and address those questions, because ultimately that's our goal, is to try to address the questions that are meaningful and helpful to you. And so getting into the presentation, Planning Commission 101, we're going to hit on some basic kind of overview, high-level concepts and principles that you as planning commissioners, city council members, staff members for planning and zoning can hopefully keep in mind, and that are helpful to keep in mind from a legal standpoint when you're making land use decisions. So the first place we always like to start, kind of the high-level view of everything, is with the Takings Clause of the Fifth Amendment of the U.S. Constitution and Article 1, Section 22 of the Utah Constitution. So both are applicable to state and local governments. You know, the Fifth Amendment, private property shall not be taken for public use without just compensation. The Utah Constitution adds that it shouldn't be taken or damaged for public use without just compensation. And admittedly, you won't deal directly, right, with the Fifth Amendment, with the Takings Clause. on your day-to-day work with planning commissions and planning and zoning. But the principles kind of permeate everything that you'll do, right? And they're generally applicable and important to keep in mind as you administer your rules and your decisions. They have property rights implications, right? Specifically, looking at the takings clause, often what we think of when we think of the takings clause is eminent domain, right? The government needs to widen a road. They need to, take a little space for some public improvement. Those are known as physical takings, right? And again, you won't necessarily have a lot of involvement. Maybe you do at this time. Maybe right now you're really growing and developing and you're involved with eminent domain a lot. But on a day-to-day basis with planning commissions and city staff, you won't deal a lot with physical takings, but the courts have also recognized, a category known as regulatory takings. Essentially, regulations can become takings of property under certain circumstances. And so again, it's important to keep those principles in mind as you are regulations, drafting rules, and applying those people on an individual basis. So the U.S. Supreme Court in 2005 said a primary role of the takings clause is to bar government from forcing some people alone to bear public burdens, which, in all fairness and justice, should be borne by the public as a whole. So this is just kind of a principle that I wanted to throw out there and put up there to keep in mind as you are considering regulations to put in place, as you are applying regulations that are in place. Is it a situation, right, where you're imposing a requirement on someone, or the regulations in place impose a requirement on someone that maybe should be borne by the public as a whole, that should be spread out more broadly? That's a principle that I think is important to keep in mind when planning commissions are making legislative recommendations, which we'll get into and talk about, and also when they're exercising administrative discretion and imposing administrative decisions. So with that in mind, as attorneys, we always like to talk about where our authority comes from, right? Back in 1926, the U.S. Supreme Court said that the zoning ordinance in its general scope and dominant features is a valid exercise of authority. The reason this even came up was, and to give you kind of a background of where zoning really came from in the first place, as I understand it, in the United States, there was the Industrial Revolution. There was dirty factories in urban areas, and there came a period of time in which those industrial uses began to encroach and grow and start to move outside of urban areas into suburban, exurban, rural areas. And as somewhat of a response to that, local communities were concerned, right? Because there were factories going down in the middle of, you probably heard the stories about factories going down in residential areas, concrete plants with pounding and different things like that, really causing problems. And so to try to separate these uses and create some order, local governments started to put in place zoning districts, right? And saying, okay, they started to regulate according to uses and saying, okay, in this area you can use these you can use your land in these ways. In this areas you can use your land in these types of ways. And this was new to a lot of people. And in Euclid, Ohio, just outside of Cleveland, there was one such property owner who, in the city of Euclid, they put a zoning ordinance in place, and they zoned his land for specific uses. And he was concerned. He thought, hey, this is taking my property rights, and I think this is a unlawful exercise of government authority. And the Supreme Court said, to promote order and good communities, local governments have the authority under their police power, which is essentially the power to regulate for the health, safety, and welfare, to zone, to put in place zoning districts, right? So that is a valid use of authority. And from there, zoning really started to promulgate and grow and become kind of the norm, right? But there are limits, right? In the U.S. Supreme Court in 1922 said the general rule, at least when talking about regulations and whether or not they ever become takings, is that while property may be regulated to a certain extent. If regulation goes too far, it will be recognized as a taking. So there's an acknowledgement there that there has to be limits. And now, the courts over the years have struggled to draw the lines in the sand about where exactly constitutes too far, right, in a government regulation. And you know, they've come up with some different types of tests, looked at whether or not you're taking all economically viable use of land, and if you're not taking all economically viable use of land, are you encroaching on certain investment-backed expectations? If you ever want to get into a really awesome conversation about that, feel free to give us a call. We won't get into it too far here, other than just to say that regulations, the courts have said, can go too far in regulating people's lands, and that's something to keep in mind and to consider as you're doing your daily work in planning and zoning and with planning commissions and city councils. So how does that apply to planning commissions, right? Land use regulations, in our view, should attempt to strike the balance between protecting individual property rights and promoting the public interest. If you do that, there's a really good chance you won't go too far, right? And we have state statutes in place, LUDMA, we're going to talk about in a minute, and case law that lay out ground rules to promote the public interest while at the same time preserving property rights of property owners and developers. So again, going back to the authority, you know, the Supreme Court said that under police power, the state has the authority to regulate for the health, safety, and welfare and to zone. The state delegates that authority to local governments through the Land Use Development and Management Act, which is a state statute, a state law. It's otherwise known as LUDMA or LUDMA, depending on who you ask how to pronounce it. For municipalities and cities, it's in the Utah Code, Chapter 10.9a, and for counties, it's in 1727a. I will provide a few references to authority to the statutes here in the presentation. Most of the time, I reference municipalities just for simplicity's sake. In a lot of ways, and in most ways, the LUDMA for municipalities and counties is the same, right? There are a few differences, and if there are differences, I'll reference those. But as a general rule, they say the same thing for both. I debated whether or not to put this in here because there's a lot of words, but I thought it would be helpful to read through just to get an idea of what the purpose of the Land Use Development and Management Act is. Again, for background as you're doing your work and considering you know, what laws to implement, how to craft your general plan, and also in administering land use ordinances. So, you know, the purposes of LUDMA are to provide for the health, safety, and welfare, promote prosperity, improve morals, peace and good order, comfort, convenience, aesthetics, and you can read through that on your own. But essentially, you know, it's to create good communities, provide for order, right? And then the number 2 gives you the authority, right? It says to accomplish the purposes of this chapter, municipalities may enact all ordinances, resolutions, rules, and may enter into other forms of land use controls and development agreements that they consider necessary or appropriate for the use and development of land within a municipality, including ordinances, resolutions, rules, restricted covenants, easements, development agreements, governing uses, and so in other words, the reason I kind of put this in here is to show that you as local governments really do have a broad grant of authority, right, to provide for the health, safety, and welfare of your communities, specifically as it relates to the use of land. But at the same time, you know, there are limits, and that's what the substantive provisions of LUDMA goes through and does. It sets kind of the ground rules, the parameters, the boundaries for local governments to operate within in enacting their local ordinances and making local decisions, theoretically and hopefully for the purpose of ensuring that the proper balance is struck, right, between preserving and protecting individual property rights, but also promoting and building good communities. So moving into traditional roles of the Planning Commission, right, and in implementing the purposes and the goals of the Land Use Management and Development Act. Traditionally, Planning Commission had 2 primary roles, right? The role of legislative, they've had a role in making the law, that's the legislative role, and also an administrative role, or a role in applying the law. So LUDMA was enacted in 2005, and it actually did a lot to kind of change the rules a little bit, in the sense that it allowed local governments to delegate a lot of the administrative duties of planning commissions to other land use authorities, whether that be local staff or hearing officers. And we're going to talk about the reason why that is, why LUDMA was set up to enable local governments to delegate a lot of the administrative duties to entities other than the Planning Commission. So looking at LUDMA and the roles and powers and duties of planning commissions, planning commissions, so these are as described and defined in the Land Use Management and Development Act, the primary roles of a planning commission. So these are the things that, as planning commissioners, staff that supports planning commissions, and also city councils in understanding how planning commissions can be helpful. These are the things to know about what their primary roles and duties are. So under LUDMA, the Planning Commission makes recommendations to the legislative body for a general plan, 2 land use regulations, which we'll talk more about what constitutes a land use regulation, but it's ordinances, zoning maps, etc. They delegate authority to one or more land use authorities to hear and act on the land use application. So that's that administrative role, right? Really the only mandatory role that planning commissions have in that area is determining, right, who to identify or who to designate as a land use authority. They also make recommendations delegating authority to at least one appeal authority. We won't talk too much about appeal authorities in this presentation. Jim Wright in our office not too long ago did a really good presentation for the trust on appeal authorities. If you have questions about that, we encourage you to review that, go back and look at that presentation. And then, their final mandatory duty is to create an efficient and fair land use application and review process. So the reason I throw this up here and share this is to show that as far as what your primary duties are in planning and as a planning commission, LUDMA states that your primary duty is in the legislative realm, right? Not in actually enacting laws yourself, but planning commissions, they need to be the experts, right, on land use laws and land use and planning in their communities, because essentially they're an advisory body, an advisory committee to city councils with regards to what they want their community to look like and rules to help implement that plan, right? And also in implementing that plan and creating and establishing a fair and efficient land use application process. So please keep that foremost in your mind at all times as planning commissioners and city council members, because we know in our office that you can really get caught up into the day-to-day of administering the law as a planning commission, right? Essentially, your primary role is to be an advisory body in creating a general plan and then drafting and recommending land use regulations, so that when it comes time to administer the law, if you have a good general plan, if you have a good land use regulation in place, then everything really should hopefully fall into place, theoretically. So spending a bulk of your time on those types of things is really beneficial and really helpful to your communities, and it will, reduce your exposure to liability and challenges from applicants in the future. If you have really good, clear goals and a vision for your community through a general plan, and if you have really good land use regulations to implement that goal. So we're going to briefly touch on the general plan and land use regulations just to give you some ideas on how you can approach these things. The general plan we are going to touch on only briefly because you have a lot of resources at your hands to know how to implement a good general plan. Essentially, in doing so, it's important to understand that the general plan it's a visioning document. You're looking 15 to 20 years into the future, and you're saying, what do we want our community to look like, what do we want our community to be? This process, it takes great time, it takes great effort, it takes careful consideration. We encourage you to follow the guidance of staff members, professional planners, in determining how to really draft and create a good plan for your communities as an advisory and a guiding document for what you want your communities to look like. And it also provides property owners and developers with the resources they need to be able to see, okay, this is what this community needs to look like. These are the goals they have. There was a good textbook in which I found the elements of a comprehensive planning process that produce a good and effective general plan include data gathering, data analysis, policy making, implementation, and monitoring. So you're gathering information from the community. You're asking stakeholders and property owners and residents, what do we want our community to look like? You're looking at that data, you're recommending policy, and then you're implementing it through land use regulations, monitoring, and then revising, right? So there's also provisions in the general plan to regularly review your general plan and revise as necessary. We encourage you to really take the opportunity to try to make a good general plan for your community and involve the public in that process, and also involve stakeholders to try to come up with something that's going to be a good vision for your community. Once that's in place, then you implement your general plan through land use regulations. And this is really kind of the bridging, it bridges the gap, right? And because the general plan is largely an advisory document, right? It's really not mandatory in any way unless your local code makes it mandatory in some way. But the rules that are going to govern the use of land are your land use regulations. And LUDMA says that a land use regulation, an ordinance, law, code, map, resolution, specification, fee, or rule that governs the use or development of land. So that covers a lot of bases, right? As far as what a land use regulation is, and it's important to ensure that all these part of the reason for putting this in LUDMA. Just recently, they put this definition into LUDMA to ensure that all of these things, including specifications, maps, resolutions, go through the legislative process so that there is public input on what a regulation should look like and what a regulation should be. What is an effective land use regulation? Effective land use regulation clearly and accurately implements the visions and goals of the general plan. The idea here is make sure that your land use regulations implement the general plan, right? And in making land use regulations, specific things to keep in mind. So this is another provision that was recently put into LUDMA to clarify, right? The rules were already in place and the law already said this in case law, but stakeholders decided that they would put this into LUDMA just to make sure everyone is on the same page and everyone knows, right? And it says a land use authority shall apply the plain language of land use regulations. And if a land use regulation does not plainly restrict a land use application, the land use authority shall interpret and apply the land use regulation to favor the land use application. So there have been multiple times in our office where we've seen situations where there's essentially a poorly written land use ordinance or a poorly written land use regulation. It's vague. It doesn't specifically say what the drafters intended it to say. An application comes in for approval, development approval, and it complies with all the requirements of the ordinance, but nonetheless the planning commission or the city council says, well, this was not what we intended, right? If the land use regulation does not plainly restrict a land use application, then the land use authority shall interpret and apply the land use regulation to favor the land use application. So this means that it's incredibly important that as planning commissions, when you're looking at your land use regulations that are in place or when you're drafting new land use regulations, that you ask the question, is this land use regulation going to do what we want it to do, right? have multiple people look at it, have multiple people read it. If they're interpreting it in different ways, you'll probably want to tighten up the language. Because if someone comes in, if the property owner developer comes in and wants to do something and it complies with the plain language of the land use regulation, then they're going to be entitled to approval, right? And so for everyone involved, it's wise to make sure that your land use regulations are clear, that they are plain. So a couple recommendations in looking at that. Arrange similar subjects together by chapter, right? There's been multiple times where, and you're probably familiar as staff with situations where you discover a new provision in the code, right? that may be applicable to a certain land use application, but it's not with all the other applicable land use applications or similar land use applications or land use ordinances applicable to a specific land use application. So arrange similar subjects together so that people know where everything is, so that it creates a situation where you're also not applying rules that should be applied, right? Also make your ordinances well organized, readable, and understandable, right? I pulled this little table out of a book, 21st Century Land Development Code, which gives recommendations on how to draft codes, right? And it just relates to making your language clear and understandable, right? As planning commissions, it's helpful that if you have a lot of applications coming through and you feel like that the ordinance really isn't addressing them in a way that you feel they were intended to address them, maybe it's time to revisit some of those provisions, right? And redraft them in a way that's going to be helpful. Short or vague codes are not better unless the local government is willing to let the courts interpret the codes for them. What that means is essentially, there's sometimes an idea out there that, well, if we keep it really broad and vague, then we'll have more discretion if something comes through to make decisions the way we want to make them. That's not what the law says. Essentially, the law says if provisions are overbroad or if they're vague, then they're going to be interpreted in a way that's going to favor the property owners. So if you want an ordinance to do something, use clear descriptive language, maybe even use graphics to illustrate the text of the language so that it's very clear what you want them to say, and this will reduce the opportunity and the possibility of your decisions being challenged, right? So ultimately, when you're looking at drafting and amending land use regulations, questions to ask: is it easy to find all applicable regulations in the code? Is the code easy to understand and apply to a specific application? Is the code regularly producing the desired or intended results? Planning commissions should spend a lot of time on this, right? They should spend a lot of time looking at their land use regulations, going over them, deciding whether or not they're doing and creating the community that your general plan intends to create, right? And that you want created. Briefly with the zoning map as well, essentially here, hopefully it's pretty straightforward what a zoning map should do, right? You're basically taking the regulations and deciding what areas of town you want them to apply. This is a general zoning map from Cambridge, Massachusetts, just to show that it can get a little complicated, right? Your community doesn't have to look like this, right? You can be a lot more simple. But when you're making decisions about how to zone land, it's important to keep in mind the consideration of individual property owners. It's important to keep in mind the desires of the community, right? And what they want their community to look like. How much commercial do we want? How much residential do we want? Do we want industrial? What about open space? Those types of things. Your general plan should give you a lot of guidance on that as well. But as requests for zoning changes come in, that's a legislative decision, and it's important to consider, all the stakeholders involved and what their desires are. Looking at that, right, it's important to know what your discretion is in legislative decisions. So we've talked about, drafting ordinances, making rules, putting in place zoning districts. The applicable standard from a legal standpoint is arbitrary, capricious, or illegal. In other words, you have a broad discretion to make these decisions and to put rules in place and to make zoning decisions, and those decisions will not be overturned as long as the decision complies with the applicable state, federal, or local law. And we put local in there because maybe your local code restricts a little bit your legislative decisions. If there are certain considerations in your local code that your local code says you should take into consideration in making zoning decisions, and you should take those into consideration, right? And so as long as a decision complies with applicable state, federal, or local law, then the decision will be upheld as long as it could promote the general welfare, or even if it is reasonably debatable that it is in the interest of the general welfare. So what that means is, as long as you have a legitimate public purpose you're pursuing, as long as you're making a decision that's going to benefit the public interest, you have a lot of discretion in deciding what you want your codes to say, how you want land to be owned, and those types of things. And it's important in making those decisions to consider public input, right? And consider the input of the property owners, and to make decisions that you think are going to be beneficial to your communities. So moving on from your legislative role in Planning Commission, and again, we do really want to emphasize that you should make it possible for your planning commissions to really spend a lot of time, right, on making those types of decisions, and making recommendations to your legislative bodies on what the rules should say, what your general plan should look like, what your community should look like from a zoning standpoint. Administrative decisions, that's applying the law. We're talking about commercial site plans, subdivision, conditional use permits, and building permits. Those are some examples of administrative decisions. Who should review administrative land use applications? We put this question in here because it's very likely and probable that planning commissions are playing a heavy administrative role in a lot of communities. We know that they are, but they don't necessarily have to, right? So one role that a planning commission has is to look at who their land use authorities are, who's approving land use applications, and to decide whether or not that should be changed, right? Building permits is a really common example of a land use application that in almost every community, the role of approving land use or building permits is delegated to staff, right? Because there's not a lot of discretion involved. It's really just looking at your code, deciding whether or not the application complies with the code, and then issuing the approval or denial based upon on those factors, right? So one thing to consider as a planning commission potentially is, if you feel like a lot of times a lot of applications that come through, you're just acting as a rubber stamp, right, for the staff's analysis on what they've done, on their determination of whether or not an application complies. Maybe those applications should be delegated, right, to staff to free up your time as a planning commission to focus on your other and primary duties of creating good general plans and creating good land use regulations and creating a fair and efficient process. So we throw that out there just as one thing to keep in mind. That said, you're still going to be making administrative decisions likely, and so what is the discretion? What is the standard? Right? We talked about the standard for legislative decisions. It shouldn't be arbitrary, capricious, or illegal. That same standard applies to administrative decisions, but the definitions are a little different, right? So similarly, when you're making administrative decisions, your decisions can't be illegal, right? In other words, a municipality or county is bound by the terms and standards of applicable land use regulations and shall comply with mandatory provisions of those regulations, right? So that goes back to that whole plain language discussion, right? If the language plainly restricts something, then you as a community need to apply those restrictions, and property owners are also entitled to approval under those restrictions, right? So if buildings can't exceed 35 feet in your code, then if a proposal comes in and wants to build to 40 feet, you can't approve that, right? It needs to comply with the mandatory provisions of those regulations. What about discretionary provisions? So what is a discretionary provision, right? There are often provisions in your code that allow you to grant allowances or exceptions based on articulated decision criteria. Also, another discretionary provision may involve imposing conditions on conditional use permits in accordance with applicable standards. So in making those discretionary decisions, the courts have said that a zoning ordinance must set some ascertainable boundaries on the exercise of discretion by a zoning authority, and ordinances should include standards to direct the inquiry and deliberation of the zoning authority. In other words, so you need to put standards in place, right, to guide your inquiry, and then once those standards in place, they need to be supported by substantial evidence in the record. So, if you have a discretionary provision, so what is substantial evidence? Substantial evidence is that quantum and quality of relevant evidence that is adequate to convince a reasonable mind to support a conclusion. It's more than a small amount of evidence, though something less than the weight of the evidence. So in other words, when making your decisions, if you have discretion to make decisions in the code, then you have to, if it's an administrative decision, you have to support it with evidence, right? It can't be based on public opinion, like in the legislative context, or public preferences, right? It has to be something based upon evidence. A really clear and clean example is if your code says something to the effect of a land use authority may require the developer to include stub roads to parcels that will otherwise be landlocked as a result of development, then, if you do require those stub roads, that decision needs to be supported by substantial evidence. It needs to be supported by some relevant, credible, factual evidence, right? And in this case, the evidence is going to be really clear because you'll be able to look at a map and decide, okay, is this development going to landlock some parcel? And if so, then you can exercise that discretion to require a stub road, right? With traffic decisions, often the best evidence is found in traffic studies, right? Done by experts and engineers, traffic engineers in the who are experts in their field. And then another thing to ensure is that the evidence is in the record. There was just a recent case in Utah that came out that said the orderly functioning of the process of substantial evidence review requires that the grounds upon which the land use authority acted be clearly disclosed in the record. This is required in part to assure more careful administrative consideration and to keep the land use authority within its discretion or within its jurisdiction. So in making discretionary decisions, make sure that you always include your reasons in your evidence for why those decisions were made in the record. So again, administrative decisions, discretionary decisions, those are things like conditional use permits, right? That seems to be a really common type of administrative decision that planning commissions get involved in, but also subdivision approvals, site plan approvals, and those different types of things. I see we're running a little short on time, so I'm going to skip a few things that we prepared. If you do have any questions about conditional uses, different things like that, please give us a call. We'd love to talk to you about them, have a specific conversation with you on how you can better implement those in your communities. The last thing we wanted to touch on was this concept of exactions. This is a question that's been coming up a lot in our office. A question of what can be required by a local government as far as exactions are concerned. So a development exaction is a government mandated contribution of property imposed as a condition of development approval. A really common exaction is roads, right? If you have a development coming in, you need to be able to serve that development, and so you require that the development put roads in place, right? And when we're talking about exactions, it's really a question of impacts, right? You're looking at what impact is this development having on our community, and you're seeking to offset that impact. So coming back to a question a quote we looked at previously, a primary role taken clause is to bar government from forcing some people alone to bear public burdens which, in all fairness and justice, should be borne by the public as a whole, right? And that kind of undergirds the rules involving exactions. So if you're going to impose a requirement on a developer to construct some sort of a public improvement, whether that be a road, sewer lift station, sewer lines, water lines, those requirements for developers to install and construct public improvements are valid and proportionate when they offset the costs of the local government of a development's impact. And that's the legal standards, that exactions have to be roughly proportionate in nature and extent to the impact that the development is having on the community. And an excessive exaction requires essentially a developer to pay for impacts beyond his own development activity. So when you're requiring certain public improvements, it's important to look at the proposal and say, okay, are we requiring more than what simply offsets the impact of the proposed development application? And if they are, there's a possibility that you're violating the exaction rules. And if you do have questions about this, please get in contact with our office. We're happy to talk to you about it. It's kind of a nuanced subject. And if you do have any questions, we really encourage you to reach out, and we can kind of help you through that process as well. So with that in mind, I know we've kind of flown through a lot of things here. I hope some of it was helpful. Please, if you have further questions on anything specifically, if there's anything you'd like to discuss, give us a call. Here's my phone number and email address. Thanks for tuning in and listening. So,
well, Jordan, we had a couple of questions. How often should code be reviewed? You said that should be regular, that the Planning Commission should be looking at this. Is there kind of a guideline how often these codes should be reviewed?
Yeah, that's a really good question. And I'd say, honestly, review them as often as is necessary, right? As far as a general standard, right? I mean, you could review them every 5 to 10 years. Essentially, what I look at is if you have a lot of applications coming in and then you're surprised, right? Every time an application comes in, if you find yourself being surprised a lot about what the code says, to me, that's the best time, right? To look at your codes and to revise them is if you're getting applications that are surprising you as far as in the sense that, hey, I didn't know that we allowed, this use in this zone, or these regulations really aren't producing good development in our community, right? If you see that a lot, then those are probably really good indicators that it's time to review your code. But as far as a specific time, I don't know that there's any specific standard. Another good time to look at it is every time the legislature meets, right? The Utah legislature, because sometimes they'll put new rules in place or they'll clarify things. Sometimes it's good at that point to look and see if your local code complies with state law every year. So those are kind of some guidelines that I'd say.
Okay, another question that we had was if you'd be willing to allow us to send out this presentation, the slides from your presentation to the attendees.
Definitely, yep, we'll make them available.
And then we have had a request to hear about conditional use permits.
Oh,
they said that's what we came for, was to hear about conditional uses. Is there a chance that you could touch on that?
Sure, yeah. If everyone's interested and have time, let's do it. So conditional uses, and so let me put out the caveat that if you have specific questions, give me a call. We're happy to talk about specific problems or issues you're having. And we understand that conditional uses, it is a big issue. I apologize that I didn't use my time wisely and didn't get to this the way I should have. But conditional uses, essentially, there's two types of uses, right? There's conditional uses and there's permitted uses. The idea behind a conditional use is that it's a unique use in the community that you want in your community, but it may have certain characteristics or potential impacts that may not be compatible or are only compatible if certain conditions are required that mitigate or eliminate detrimental impacts. So that's the definition, right? And the important thing to keep in mind with conditional uses, a lot of people look at conditional uses and they think, okay, there's this possibility, right, that I can deny this conditional use if I don't like it. That's not the case, right? Since it is an administrative decision, what the law says is a conditional use shall be approved if reasonable conditions are proposed or can be imposed to mitigate the reasonably anticipated detrimental effects of the proposed use in accordance with applicable standards. So there's two things there, right? You want your code to have really good standards, right, about what governs conditional uses. You know, if you want to make sure that all conditional uses don't have adverse traffic impacts, and include a standard in your ordinance about traffic, right? If you're concerned about parking, include a standard in there that addresses parking. Maybe, you know, something to the effect that all conditional uses shall, you know, address their parking concerns, even if they go above and beyond minimum parking standards, right? And if you have those good standards, then if a certain use comes in and you look at the use and it has potentially detrimental impacts on the community, then you can impose additional reasonable conditions, whether it's related to parking or, you know, traffic concerns, lighting, noise, hours of operation. You can impose additional reasonable conditions to address those impacts and address those concerns. And the only situation in which a conditional use can be denied, right, is if there's no possible way to mitigate the detrimental effects of a conditional use by imposing reasonable conditions. So if there's just no possible way to do that, only in that scenario can you deny a conditional use. And admittedly, thus far from what we've seen, there's never been a case that's been brought to the Utah courts where the denial of a conditional use permit has been upheld, right? Because in almost every situation, there is a situation where you can impose reasonable conditions, right, to mitigate any potentially detrimental impacts that may be anticipated. The advice that we always give communities is if you have a lot of conditional use permits coming in that you think should be denied, right, or that you'd like to deny, just take that use out of your code, right? If there's any possibility that that's a use you don't want in a certain area or a certain zone, instead of putting it in as a conditional use, just make it a not permitted use, right? And only make conditional uses uses that you are going to be comfortable with in your community, because odds are they are going to need to be approved. So,
hey Jordan, on that, while you've brought that point up, it's been brought up certain types of uses may be objectionable to our community, but there may be some constitutional grounds. Speaking of sexually oriented businesses, things like that, do we need
right.
to provide a place where those conditional uses can be?
So sexually oriented businesses specifically, yeah, there's a lot of federal implications and constitutional implications involved, right? If you have questions about those specifically, I'd recommend contacting our office and talking about the specific scenario. You know, it is kind of a First Amendment question, and I don't really want to give kind of a general rule for those, because it is kind of a fact-specific inquiry, and usually it is going to be the case where, well, it's arguable, I think, you know, whether or not one specific community needs to allow for sexually oriented businesses. It's likely that they do, right? But as far as specific uses, you can regulate them, though, right? According to time, place, and manner. You know, that's kind of the free speech standard. And if you want to get into that further, I would definitely recommend giving our office a call to discuss in your specific scenario how those can be handled and treated. So.
Okay. Can I ask one question just on conditions as far as we start talking about sights, sounds, or noise and things like that. When you create a condition, do those need to be measurable, or can we be general in asking a question? What about, noise must be controlled? Is there?
Yeah, good question. The more vague your condition is, the same rules are going to apply as far as interpretation, right? So a good noise, your standard can be broader, right? And say, for conditional uses, we want to make sure that any noise concerns are addressed and mitigated, right? When you're looking at a specific application, let's say it's a reception center and they're going to have outdoor bands or something like that, right? Then in that case, the more specific your condition, the better, right? Because the applicant is going to know what they're going to be expected to do, and the community is going to know exactly what the condition is going to do, right? So, something to the effect of keeping noise under a certain decibel level and restricting the time that the bands can play from 8 a.m. to 9 p.m. or something like that. The more specific, the better, just from a predictability standpoint, so that no one has any surprises. So,
okay, that makes a lot of sense. A couple of questions we have here. Uses that are not listed as permitted or a conditional use in any zone are therefore not allowed anywhere. Is that correct?
So that's a really good question. It honestly depends on your code. It really does. There's a Utah Supreme Court case out there involving short-term rentals, where short-term rentals simply weren't addressed, and the court found that they were, as a result, permitted because the code did not restrict them. Now, in our opinion, a way to address that is to have a provision in the code, something to the effect that says, any use that is not expressly permitted is otherwise prohibited. Something like that, I think, would address that type of a scenario. The case involving the short-term rentals, it didn't have anything like that, right? And so since it wasn't specifically prohibited, it was permitted, right? But and again, this has never been addressed by the court specifically, but most codes that I've seen, they do have some sort of provision that says if they are not expressly permitted, they're otherwise prohibited. I think that should cover that scenario, so that, when you do have a zone and it lists specifically permitted uses, then that catch-all provision of if not specifically permitted, it's otherwise prohibited, should cover what you're trying to do and prohibit any of the not listed uses. So.
Okay, great. It looks like we're bumping up against an hour. We probably should wrap up the webinar now. But thank you very much for your presentation. That has been very enlightening. I know I sit on a planning commission, and a lot of these questions, even though I've been there for a while, these are important considerations that we need to regularly look into. So we invite you to share this information with your commissions out there, and we appreciate your attendance here. Jordan, final word.
No, I think I'm good. So thank you.
Awesome. Thank you very much. And make sure Jordan shared his contact information. The folks at the Ombudsman's office are very approachable, very open to questions, and they're a great resource for each of us to get those tough questions answered. So make sure you give Jordan a call, and if there's a question, run it past them. That's why they're there. All right. Thank you very much. We appreciate your presentation. Appreciate everybody's attendance. We're going to wrap up now. Everybody have a great day. One more button first.